Good evening, everyone. So today we're going to present about the issue concerning the copyright of Taylor Swift over her own song. So we are from Group A, and my friend is going to present about the fact.
So Taylor Swift case, there are four main actors in this case. The first one is Taylor Swift, who is the artist of the song, and Schumer is the owner of the new record company, and Big Machine Record, the former record company, and the last one is Haka Holdings, which is the new owner of the record company. So next is the facts. The issue concerning the copyright of the Taylor Swift over the whole song. At the age of 15, Taylor had entered into the contract with Big Machine Record, which she gave away her master right. Then next, when the contract expired between the Taylor Swift and Big Machine Record, she had to regain her master right back. However, the Big Machine Record said that if she released one album, then she will get the former album back. However, Taylor Swift was not agree with this condition, so she tried to buy her former album back from the new record company. But later, the Big Machine Record company sold to was sold to Ithaca Holding, was that owned by Schumer, who has a personal conflict with Taylor. Then Taylor Swift. Then the Taylor Swift chose to re-record all her new songs.
So the first legal issue that our group come up is whether Taylor Swift can re-record her own song or not. So to answer this, it will depend on the cause of the contract, since most standard music contract have a clause prohibiting the artist from re-recording their own music for a specific period of time. And in this case, according to the interview of Taylor Swift, the period will be end in November 2020 for her first 5 album, and as a result, she will be able to re-record her music. So, for the legal analysis, so in the US, for a single song, there's two separate parts. The first one is the master right, and the second one is the publishing right. So, first for the master right is the right over the master recording, or which is basically the song that we usually hear on the radio. So, this copyright is usually held by the record label. And second, the publishing right. So this one is the right over the musical arrangement and the lyrics, which the owner of the right is entitled to modify or bringing the music to perform live on stage. So in this case, because Taylor Swift write her own song, so she can record it without much trouble, and because the copyright in the actual recording of a song or the master recording is distinguishable from the copyright of the composition of the song or the release. So in this case, she will be able to re-record. So what does this mean to have two versions of the song at the same time? So basically, the original master recording wouldn't disappear, so there will be two sets of songs, and as a result, it can cause the value of each song. Like for example, since there is two sets or two versions of the song, and the company might attempt to negotiate to license both songs from like the old one, the new one, and choosing the cheaper version.
Now, the next issue is concerned, should we amend the section 203 of US Copyright Act to reduce the period of termination? I will begin with what section 203 says. So section 203A is talking about the conditions for termination. And there are many subsections under this. However, what we will focus on is the subsection 3, which mentions about the termination of transfers and license granted by the author. So section 203 said that condition for termination is the exclusive or non-exclusive grant of grant of a transfer or license of copyright act of copyright is subject to a termination under the following conditions. And subsection 3 says that termination of a grant may be effected at any time during the period of the end of the 5 years of the end of the 35 years from the date of the grant. So now come back to our question that whether we should amend this section of 203 to reduce the period of 35 years, which is the period that the author or Taylor Swift in this case can terminate the master sound recording right that she has granted to the recording company. So the factors that we will take into consideration is first, the interpretation of section 203 of the US Copyright Act. This section aims to protect the current owners, which is the artist of the work, and since it gives the artist the right to termination. And the second point we should take into consideration is the period. This period of 35 years of termination can be considered too long if we take into account to the fact that in general the value of the song is often at peak when the song is released, and its value will decrease after a certain period of time. So under this provision, the master right will be elapsed after 35 years, which means that at the end of the operation, the value of the song will decrease, and therefore our group believes that the period of 35 years is considered too long. That seems to be unfair to the artist himself, and hence we should amend the law of this 35 years to be shorter to the extent that it seems appropriate. And the next issue we're going to talk about is what is the consequence if we amend the law.
Despite many benefits from our proposal, but the effect, if we change this section, it will affect all kind of copyright work, which the value of it does not depend on the popularity like the song. And so our opinion, we think that it may be better if we amend the law to deal with specific case where the master right was granted. So the issue should we have a new law to prevent the record complicate master right? On one hand, the most time the record company is the one who hold the master right, since they have more bargaining power, or maybe because the new artist lack of legal knowledge and does not consider the consequence when they gave away their master right. On the other hand, it may seem that this law promotes fairness only in the aspect of the new artist, since in the record company also have to invest, and there are many people who taking this part in one song. So this is debatable issue, and our group does not have a settlement.
So, about if this case applies to the Thai copyright law, according to section 15 under Thai copyright law, the copyright owner will have the exclusive right to reproduction or adaptation, communicate to public, letting of high of original, or giving benefit to other, and about right to license. So, in this case, we separate the work into three types under the Thai copyright law under section 6. The lyrics is the literary work, the melody is a musical word and the master is already record is a sound recording. So that means Taylor, who is the author of the literary work and the musical work, she has the copyright owner over both of these. So Taylor can re-recordings or of her song since it is the right to reproduction under section 15. And by the way, big machines still have the copyright owner or the master of the record with already record. So in Thailand, it has a lot of case about the copyrights. For example, this case, the rock band named it as cannot sing his song to the public. However, I will show this case since in practice in Thailand, most of the company will put the condition in the contract that the company will be the copyright owner of the any work we create during the time of the contract between the artist and the company.
So for additional suggestions, so our group suggests that before entering into any agreement with the record label, the artist should seek professional legal advice to negotiate with the record deal. And in case that the artist want to be the owner of the master recording, the artist must ensure that they have a written agreement between every party involved in the recording process, such as record label and recording studio, sound engineer, and other musicians involved. And however, in practical, a clause specifying a period of time for the recording is more practical, since the record label is likely to have maximized revenue from a particular song within the first year from the release of the song. And well, so the new artists often had little bargaining power when entering into the contract with the record label. So, however, many younger in this day, they publish their music on the platforms such as YouTube or SoundCloud, and they are still able to attract a large follower without the involvement of the record label. And by not being a party in the label contract, the artists are able to control their master recording and other intellectual property rights. So if an artist later choose to sign with the record label, the artist will have the artist will be able to use the leverage of his own fame and following to negotiate a more favorable deal with the label. So therefore, for our group opinion, in the upcoming years, the rapid growth of the streaming service such as YouTube or SoundCloud, along with the independent artists, will likely to make the music company reconsider on the agreement between the artists, which we think that is a change of the music industry, whether the company should be the holder of the master right of the song or not. Thank you for all.